David Barrett, please, sir. Could I please, sir, get you for the court reporter, for the jury, to say who you are?
Stephen Barrett.
And what do you do, Mr. Barrett?
Professor at the University of Houston, Conrad and Hilton College of Hotel and Restaurant Management.
What is that school?
That's, there are about 150 hotel and restaurant schools scattered throughout the United States, and ours has been in existence for about 50 years. It was founded jointly by the Mr. Hilton, Conrad Hilton, and the state of Texas. That's why his name is on it. And but we teach the science of operating hotels and restaurants, developing hotels, financing of hotels and restaurants, meetings, events, spas, things like that.
And what is it you do for that school at the University of Houston? What is your position?
Yeah, I'm a professor at the university, full professor. I've been there 25 years. Throughout my career, I've typically taught the introductory course to hospitality to the incoming freshmen, to give them a broad survey of the industry. I've also taught leadership, and as a junior senior level course, which we call a capstone course, which is where they bring all of their curriculum to play in this one particular course. And then once a year, I typically teach a graduate class called Hospitality Law, which is attended by approximately half of the students are our master's candidates, and half are typically law students from the UH Law Center, University of Houston Law Center.
Now, you said you're a full professor. What is that?
Academia can be kind of confusing to people. When you first start out, typically you start out as an assistant professor, and then you typically have 6 to 7 years to do research and publish, generate grants. Grants are donations of money to help fund research, and you have that time period in order to demonstrate your value to the university and or to the industry. And you typically are awarded tenure at that time, and typically you are promoted to associate professor. But if you don't in that 6-year period, then you have to leave the university. And then probably between 50 to 60%, I would think, that may be a little high, of the people that come in as assistants get promoted to the rank of associate, and then from associate to full, it's usually about 30% of the associates actually go on to become full professors. One of the main criteria, other than the research and teaching, is you also have to perform service at the university, serve on committees, and help them govern the university. But it's also important to achieve a national reputation in your field and your expertise, to be considered a thought leader in a national perspective. And then in order typically to become from an associate professor to a full professor, you typically have had to develop an international reputation as an expert or a thought leader in your area of expertise.
Now, the students who attend the Conrad Hilton School of Hotel and Restaurant Management, they go there for what reason?
They go for a 4-year degree in Bachelor of Science in Hospitality Management. That's about 800 or 850 of our students, and we have another 125 in our master's program. They're seeking a graduate degree in hospitality. And then we have, I think, 6 candidates today in our PhD program.
Are there any other positions that you have other than the full professorship that you have at the school there at University of Houston?
Well, that's my primary occupation, is the university and being a professor. But we have many years ago, about 20 years ago now, I started a business called HospitalityLawyer.com. It's really think about it this way. Think about it like Match.com for lawyers that want to represent hotels and restaurants. And as part of that, we developed a hospitality law conference where we converge the attorneys that represent, the private attorneys that represent the hotel restaurant industries, along with the corporate counsel, risk managers, and loss prevention people that work for the hotels and restaurants. So we do that.
Is there anything else that you're involved with other than the two that you've now discussed with us?
We also started about 6 years ago now a global congress on travel risk management, and what that focuses on is businesses have a duty to keep their to use reasonable care to assist their employees when they travel, to be safe and secure when they travel. And so we started this conference to have discussions around those concepts and to assist businesses in meeting their duty of care to their employees. They're what we call mobile employees, people that are traveling for business. The Hospitality Law Conference is focused mainly on domestic issues, focusing on legal safety and security aspects of operating a hotel or restaurant, whereas the Global Congress focuses on a global, obviously a global perspective, but particularly from the corporate travel community side.
Now, you've talked to us about, or talked with us about what it is that you do now. Tell us a little bit about your educational background.
I went to school at Texas Tech University in Lubbock, Texas. I received my bachelor's in economics and then my master's in communications, and then I did my law degree there as well.
Other than the teaching at the University of Houston that you've told us about, do you have any other teaching or leadership positions that you have within the industry of hotel and restaurant management?
I do a significant number of talks per year and have for probably the last 20 years to the industry about legal compliance, safety and security issues that we need to be aware of, and the preventative steps we can take to avoid challenges that might arise.
Are there any writings that you have in this area that's at issue in this case?
I've written extensively in terms of articles in trade journals, as well as some refereed articles are those that are submitted into a blind review process, so the reviewers don't know who wrote the article, and it's typically they have to be your peer level to review your information so that they can validate it and give their comments about it before it goes out to the public. I've written quite a bit about that, and then I also have a textbook that's called Hospitality Law that is published by Wiley & Sons, and it has been adopted by probably half of the hotel and restaurant schools in the country and been translated into a couple of different languages and used internationally as well.
And what does that textbook address? What does it cover?
Well, the concept of hospitality law is kind of unique in that it converges lots of aspects of the law. So when we think about hotels and restaurants, hospitality, we've got to think about the real estate side, the development. You've got to think about operations and management. You have to think about the type of business entity you want to create. You have to think about meeting contracts, and franchise agreements and management contracts. You have to think about the personal injury concepts that can arise in a hotel. You know, I guess the last time I checked, there were right at about 5 million hotel rooms in the United States, and at an average 60% occupancy rate a night, that's about 3 million occupied rooms a night. So as you might imagine, a lot of things can happen with all of those people and all of those transactions going on and all the development going on. So we talk about that, and we talk about the employment side as well. The appropriate way to hire and select the right employee for the right job, the necessary parts of training and holding people accountable from a human resources standpoint. So And we talk a little bit about the insurance side and the risk management side of the business as well.
Have you ever written any articles in industry journals?
Yes.
Tell us about that.
Well, a lot of the trade journals that are out there specifically focusing on the restaurant operator and the hotel operator, and so my work has been published there relatively frequently, that I write about, particularly on the legal safety and security side. One of the most popular ones was one called Stem the Tide of Litigation, which focuses on selecting, training, and educating and managing your people in a positive way. But I've written extensively, and there's, particularly in the trade press, I enjoy that. I think it's important to make an impact and influence when you can.
Now, have you been accepted in the courts as an expert in hotel operations, hotel security, policy and procedure development for hospitality entities, and training?
Yes.
Do you have a CV?
I do.
Your Honor, may I approach? What is that?
It's the latest iteration of my curriculum vitae.
Your Honor, I'd like to have that marked as the next numbered exhibit.
I have 37.
Your Honor, I have copies I'd like to publish to the jury. May I approach? Your Honor, at this time I would move to admit Mr. Barth as an expert in the area of the common customs and practices in hotel franchise and management, company arrangements, hotel operations relevant to this case, standards and widely accepted practices applicable to hotels related to administration, training and guest safety, operational practices of hotels such as the hotel in this case, the foreseeability of the alleged incident that occurred in this case, and the duties and operations plaintiff and ESPN relative to plaintiff's safety and security while traveling. With respect to the first one, the common custom and practices in hotel franchise and management company arrangements, what is your opinion?
May I step to the...
Yes, please.
So, try to do this quickly as I can. So let's just do it this way. We'll find out. Maybe I use colors. So you've probably heard a lot of terms. You've probably heard the French, and I apologize, I'm left-handed, so best you can. But you've probably heard the franchisor. That's the group that's selling the franchise or licensing somebody else to operate their brand, right? And that's another word you need to think about is brand, because when you think of franchisor, that's the brand. In this case, Marriott is the franchisor. It's also the brand. Yep. So typically what will happen is an ownership group that has money to invest will find a location and try to purchase a license to operate that brand because it has a reputation. So for instance, the reason the ownership group would want a franchise is because the Marriott name and their central reservation system and all their processes and procedures and training are very valuable. And you pay a significant fee for that going this way, right? So they'll do that because it gives them a greater probability of success, and if you're trying to borrow money, lenders also like an established brand. So that's why we do that. Oftentimes, though, certainly in the last 40 years in the United States, the ownership groups don't always have expertise to operate the hotel. They have expertise in development and in finance, but they don't necessarily have expertise in the operations of a hotel. So they will reach an agreement with a management company, people that do have expertise in the day-to-day operations of the hotel business, to operate the hotel. And when you have a franchise involved, then the management company needs to operate the hotel according to the expectations of the brand or the franchise. You've also heard this term, I think, the flag. Think of the flag merely as the sign that's on the hotel, right? So just to make it a little more clear, let's take Hilton, for instance. Hilton is a franchisor, Hilton is a brand, and if somebody has a Hilton hotel, that's the flag. Now it gets even a little more confusing, I'm sorry, because you have sub-brands. So Hilton has Hilton Garden Inns, but they also have Embassy Suites, right, that doesn't have the Hilton name in it. Marriott, for instance, has the Ritz-Carlton as their luxury brand. So the Ritz-Carlton is the flag, but the franchisor is still Marriott. But in this particular situation, it's pretty clear. Marriott's the franchisor, the brand was Marriott, the flag was Marriott. You have the ownership group, West End, who entered into an agreement with Windsor to operate the hotel. And we, as customers of hotels, we want ownership groups to hire management companies to operate the hotels because they have the expertise to do that.
Now, what is the relationship between, let me move before I forget you, I'm going to mark that as the next number.
Number 38.
What is the relationship in this diagram that you just drew between Marriott, Windsor, and West End?
In this particular situation, Marriott would be the franchisor. West End, the ownership group, would be the franchisee, also known as the licensee. Marriott licenses them to use their name and their policies and procedures and their training. And then, so that's the relationship between the franchisor and the franchisee. The other relationship then exists between the ownership group, West End, and Windsor, the management company. Now, typically, in a situation like this, the parties between the ownership group and the management company, they act as independent contractors, and with a limited amount of authority of the management company to enter into some agreements on behalf of the ownership group. But all of the employees are hired, managed, and or terminated by the management company. There might be, in a typical situation, there might be a few key positions where an ownership group might want a little say-so. Typically that might be the GM or the director of sales. But for the most part, the management company has the control over the day-to-day operations of the hotel. And like I said before, rightfully so, and as a customer in a hotel, we want that because they are supposed to have the expertise on how to operate that hotel. So we rely upon that.
Now, in this particular case that we're involved in today, are those three different companies?
All three different distinct entities, companies, yes.
Okay, I appreciate we've now talked about generalities of formation of our relationship between the three companies here. So let me ask you some specific questions about the opinions. But first I want to ask you this. Approximately how much time have you put in to make the analysis that you have in this case?
At least 100 hours, probably. Just so you're aware, when you get brought into a case like this, you have to gear up with everything. I think we had close to 21 or 22 depositions, and sometimes those run 250 to 300 pages. Lots of documents, what we call discovery, all the different documents I'm sure some of you have seen, and some of which you have seen. And then once you make your disclosure initial opinion, then you get deposed, but that could be several months later, so you kind of have to go back and review again, and then it's another several months before you might testify at trial. Most cases, you might need to testify at a trial, and several months later, and you have to get up to speed again. And I know that sounds like a lot of time, but that's the reason why it does take so much.
Now, in this case specifically, you've talked about generally what an expert would look at. What specifically did you look at in forming the opinions that you're going to be discussing with the jury today?
So I looked at all the discovery, the depositions that I mentioned previously, the documents that were relevant. I've also read several transcripts from the testimony that you've heard, Mr. Delmarva's, Nina, sorry, I can't remember her last name.
Rivera Key.
Thank you, that would be right. And Mr. Strachan as well. And I think that's probably all. But additionally, I typically, and I did in this case, a significant literature review of articles and books that were in a publication in 2008 and or early 2009 to see what was being written about this particular aspect, whether it was this relationship that we just discussed or the specific allegations that have been made here. I looked at each industry typically has an association, and the hotel industry is no exception to that. It has the American Hotel and Lodging Association. There's also a state hotel and lodging association for every state. There's also a local one. So I looked at the thoughts that were coming out of the American Hotel Lodging Association around this time to get some information and understanding about what the common custom and practices were during this time with the industry, the scope of the industry. They also put out a security director course to certify hotel security folks in the operations of a hotel, and I reviewed their course. Part of the depositions that I reviewed were the expert testimony for the plaintiff's side.
So have you testified for both defendants and plaintiffs in your career?
Yes.
In this case, you have said that you have opinions with respect to the hotel operations relevant to this case. What are those opinions?
Well, based upon my 25 years of teaching and working in the hospitality industry and the literature review I described for you and reviewing the facts, as well as the assessing the common custom and practices of the industry that were in play at the time this incident occurred, it's my opinion that the Vanderbilt Marriott met or exceeded its duty of care to Miss Andrews on the days that this incident occurred.
And your opinion that you've just discussed with you is based upon what? What formulates that opinion?
Well, specifically, if we have an obligation to operate our hotels with, the industry does, an obligation to operate hotels with reasonable care. And I think it's an important distinction to make that hotels are not the insurers of guest safety. Right? Let me give you an example of what I mean about that. I'm going to preface my example. Everybody that I know, myself included, have exceptional empathy for what Miss Andrews went through. I am not comparing my example to what Ms. Andrews went through. But if you think about bed bugs, it is impossible for a hotel to guarantee to a guest that they will never encounter bed bugs in their hotel room. A hotel could do everything reasonably that they could. In other words, they could have a policy to inspect, to clean. They could train their employees to do that. They could have an agreement with a reputable vendor to treat on a regular basis. They could hold their employees accountable for the inspection and sanitation aspects. Even though they did all of those things, the guest the night before that stayed in the room that I might check into could have brought the bed bugs in with them or on their luggage. I might have brought it in on my luggage. So businesses typically in the United States, and certainly with regard to the hotel industry, are not the insurers of their guest safety. Rather, they have an obligation to operate their hotels with reasonable care. And that means what would a reasonable, prudent hotel operator do under the same or similar circumstances? So when you think about reasonable care, you think about policies and procedures. You think about training. You think about compliance with policies and procedures. You think about ensuring that your people stay up with things that are going on in the industry, right? One of the other parts of this concept is foreseeability. Right? Courts have ruled repeatedly that the concept of duty of care is our obligation is...
Your Honor, objection to the legal conclusion as to what Tennessee law is. I don't believe this gentleman is licensed in Tennessee.
With respect to your teaching, what you do at the University of Houston, what is a general standard applicable in the teaching that you give to the students that you talked about?
Against the standard of reasonable care, and we look at, as part of that, you look at foreseeability. And when you think about foreseeability, think about an anticipated result from an action or inaction. Right? If I do this, could this happen? If I don't do this, could something happen? Right? So the courts, generally speaking, have decided that it's unfair to hold business responsible for items or incidents that occur that they did not know could or would occur, or that they should not have
Not the Tennessee
known.
law.
I have sustained objection that you be qualified. I don't know what the standard is in the state of Tennessee.
You've talked about that your educational background included law school. You have been a lawyer for how long?
Almost 30 years.
In the course of your 30 years, have you practiced law?
Yes.
Have you, in what classes do you teach at the University of Houston specifically? Conrad Hilton School of Management.
The introduction class, leadership and hospitality law.
And in that introduction class in hospitality law, what does that encompass?
It's a survey course around the entire industry, all the aspects of it.
Does that class include instruction with respect to foreseeability?
Sometimes. It would be a very minor part in that particular class.
Does it include the concept of reasonable care?
Again, a minor. It's a very introductory survey class, but yes, certainly it will be mentioned.
And the people that you teach this class to include who?
These are the freshman and sophomore students that are wanting to get a degree in hospitality.
In the course of your years that you have taught there at the University of Houston, approximately how many students do you think that you have taught?
325, 1,500 to 2,000.
With respect to this particular incident that's before this jury in this court here in Nashville, Tennessee, can you give opinions as of 2008?
Yes.
As of 2008, not today's.
Yes.
Do you have the opinion with respect to the policies that were in place at the Vanderbilt Marriott and procedures, policies and procedures at that location in September of 2008?
I do.
What is that opinion?
Again, based upon the qualifications you've heard about and the work that I did to come to the conclusion, I felt like the policies and procedures met or exceeded the standard of care, the expectation of behavior that existed, or the common custom and practice that was in place in 2008 for the hotel industry.
And with respect to that opinion, what do you rely upon?
Well, first I relied upon the fact that it was Marriott in general. Marriott has an outstanding reputation throughout the industry and throughout academia, and certainly with me, for doing things the right way. They're very thorough. I think so highly of them that I have had several of their folks come to visit with my students about it. I've worked with many of them at my hospitality law conference, heard their thoughts. We inducted the Marriotts into the Hall of Honor at the college because of their stature in the industry, and they are actually looked at as leaders in the industry. Most hotel companies kind of try to aspire to become Marriott, and they didn't become one of the largest hotel companies in the world by not having effective policies, procedures, and training. And so that was one. Two, the testimony that I saw from the people that worked for Windsor, it was very clear that the training and education was significant, that it was reinforced. They had daily lineups. They held each other accountable to those policies and procedures. And so I felt like that definitely were the types of things you would look for to operate with reasonable care in the hotel industry in 2008.
So you just mentioned training. Your opinion specifically as to training is what?
Well, in my opinion, the hotel met or exceeded the standard of care for training in 2008 for the hotel industry, certainly.
When you use the word standard of care, how is that defined? How are you defining that?
So you have the duty of reasonable care, and then when you think about what that duty is, it kind of is made up of levels of behavior that one needs to achieve in order to fulfill that duty, right? So when we think of the word standard, think about expectation or target, right? Some level that we're trying to achieve. So when you think about that, you can define it a couple of different ways. So for instance, all of us are familiar with a law that says you cannot drink unless you're 21 years of age. So the duty of care then for a restaurant or club or a hotel that sells alcohol is to not serve anybody that's under the age of 21. Right? And so that's one place where we find targets or standards of behavior. Another place we find them in the common customs and practices that go on in the industry in which we operate. In this case, it would have been the hotel industry that was going on in 2008. Particularly in this case, this type of hotel is known as a full-service hotel. They distinguish from a select service hotel. Select service hotel typically doesn't have a full food and beverage operation. They just have the breakfast that you might be used to. Some of those brands might be a Comfort Inn, a Comfort Suites, La Quinta. But when you talk about a full-service hotel, you're talking about a competitive set of folks that typically would have valet, concierge, significant food and beverage, room service, things like that to distinguish it. And certainly among its competitive set, the training that I saw, both the online modules that I think were produced by Marriott or the simulation training I think that they produced computer-based, as well as the training that was described in the testimony that I read by the employees. met or exceeded the standard of care at that time in 2008 for the hotel industry.
You had testified that you reviewed the testimony of Mr. Delmarva that he made in this court.
Yes.
If Mr. Delmarva has testified that he believes that the training was inadequate, do you agree or disagree with that?
I would disagree with that.
And why do you say that?
Well, the first reason, I didn't see any foundation for his opinion other than his experience in the industry, and I appreciate that. And with all due respect to Mr. Delmarva, he's been around a long time for that. But I'm not sure how one could ignore the testimony and the training and the reputation for Marriott. You have to keep in mind, ladies and gentlemen, that when somebody like Marriott franchises, in other words, licenses another party, a third party, to operate under their name, that name is very important to them. There's real value in that. That's why people like West End pay so much money to fly their name on their hotel. And so it's incumbent and huge value to Marriott to establish high standards of operations at their various franchises. And so they do that by establishing those service comfort standards, and then they make sure that it gets trained, that the management company gets trained on that. And not just any management company can operate a Marriott hotel. You have to have a significant stature in order to be able to do that, and a proven track record. And in this case, Windsor was one of the preferred management companies for Marriott and had a record of operating Marriotts in accordance with Marriott standards. And if Windsor wanted to maintain that status, then Windsor knew, and in my opinion demonstrated to us, that they took that responsibility seriously, and they implemented not only the policies and procedures that Marriott had established, but they went so far as to develop local SOPs, standard operating procedures, that had to meet or exceed Marriott's, and they went even farther, according to the testimony in some instances.
With respect to hotel policies and procedures as to guards, Mr. Delmarva has testified in this case. If he has testified that the security guards there were inadequate, what opinion, if any, do you have as to that?
I would disagree with Mr. Delmarva about that.
And you say that why?
The hotel, where I teach, so my background is based on, my foundation for that particular opinion is based a little bit upon the fact that the hotel school that I mentioned to you is also on a university campus. It's a Hilton franchise as opposed to a Marriott franchise. And hotels on university campuses are rather unique, as you might imagine. The target market for those hotels is a little different. It's typically academia related to the guests that typically stay, not always, but often. And so we typically have a higher average daily rate, and so we typically have a higher socioeconomic level of guests. Not much in the way of incidents. So for instance, in my 25 years at our hotel, we have never had a security guard on the premises. We rely on the university police, as I'm sure the Vanderbilt Marriott would. You would also want to establish, which we do at our hotel, and the Vanderbilt Marriott did as well, establish relationships with the local police who can respond quickly should there be an incident. In this particular situation, the testimony that I saw was that the employees felt very safe at the hotel. There was little evidence, if any, maybe one bank robbery that happened to come into the hotel was the only thing anybody could identify around that time frame. So the testimony was that they had security overnight from 11 to 7. They had a young man named Tim, I believe, that also acted as security during the day. And the other thing, ladies and gentlemen, Mr. Delmarva was saying needed at least 2 security guards during the day. During the day is when all of our employees are on staff. That's the highest density we have, and that's when everybody is on the hotel room floors. And you have your housekeepers there, and you have maintenance people, you have room attendants. These are the people that help the housekeeper flip the beds or strip the beds and move the sheets into the linen chute. So you've got a lot of activity going on there. So you've got a lot of eyes and ears, and at the end of the day, that's what security is supposed to be about. So I did not agree with Mr. Delmarva's thought about that. And the other reason I look at that is I think his opinion was that the hotel was trying to save money by not adding the 2 security guards. I think if you look at the investment that West End had made and that Windsor was making with their employees and the training and education they were doing for their employees, if they thought that hiring 2 security guards was necessary and foreseeable to prevent things from happening at their hotel, there's no question in my mind that they would have spent the money to do that.
Let me ask you a question. You said something interesting. I want to follow up on that. You said that there was a security guard at the Vanderbilt Marriott location. Where did you see that?
I believe I saw that in the deposition of the gentleman that ran Cumberland Security. Did I see that?
Based on what you reviewed, was there a security guard in the daytime?
Well, there was my understanding was a gentleman named Tim who acted as security. He did other things, but he acted as security or was available to do that. Pretty large guy.
So if Mr. Delmarva has testified that there was no security there,
right?
Is that correct based on what you reviewed?
That would not be correct.
With respect to well, let me ask you this. Mr. Delmarva testified as to surveillance cameras. Did you see that testimony?
Yes.
What opinion, if any, do you have with respect to whether there was a need to have surveillance cameras at that Vanderbilt Marriott location in 2008?
Well, I agree. Security cameras are helpful, but it certainly would not have been the common custom and practice in 2008 or today for hotels to install security cameras with views of the hallways of the hotels. You might find that, but it would be very rare. And in my opinion, it's more than likely for the operating company, the management group, to keep tabs on their employees and housekeepers rather than deterrent. Not saying it couldn't act as a deterrent, but you just would not see them on the hotel room floors. And to be fair, you might see them in Las Vegas, where lots of money is moving around there, but even then you typically, where guests have an expectation of privacy, you wouldn't have the camera down the hallway, but you would find them probably facing the elevators. But that's more of a protective device for the hotel, because those casinos have so much traffic. They get a lot of claims for trips and falls getting in and out of elevators, that they will install those elevators for a couple of reasons. One, in case something happens, and number two, to go back and be able to review an incident or an accident that actually happened on the property.
In 2008, was it the common custom and practice in the hotel industry to have surveillance cameras on guest room floors?
No.
Why is that?
Well, in this business, we're always trying to balance customer care, expectation of privacy with safety and security. And that's one of those areas that guests feel like the guest room floor is kind of their domain. Right? And so typically we would not want to infringe upon that.
What opinion, if any, do you have with respect to the process of check-in of guests at the Vanderbilt Marriott in September of 2008, whether it was proper, whether it was deficient?
I thought their policies and procedures were congruent with Marriott's policies and procedures, and I felt like they were certainly met or exceeded the standard of care in the industry in 2008.
Mr. Delmarva had also talked about a telephone that the Marriott, Vanderbilt Marriott had at that location. Are you familiar with that telephone?
To the extent it's been described, I think there's some discrepancy over exactly where it was located, but I believe I understand the type of phone he was speaking of.
What type of phone is that?
I'm sure most of you have been on a hotel room floor where there's a phone outside the elevators or somewhere in the hallway. That's known as a house phone. So typically when we pick that phone up, it should ring directly to the front desk. And it will not have an LED display on it designate any rooms or names. What we call the back of the house phone is for the employees of the hotel in particular areas that need to know the guest name or room number for several purposes. One might be if I'm at the restaurant, I need to be able to use the guest name when I pick up the phone. Rather than how may I help you, I would say, how can I help the Smith party today? And that's part of the customer care that we talked about earlier that hotels are constantly trying to deliver. And if you have a room number, then that makes it easier for room service to be delivered. It makes it easier for the front desk to understand who we're talking to should somebody need something to be delivered. And it's also a safety and security function, because if somebody calls down an emergency and cannot remember their room number, then we have that displayed. But there's a distinction between a house phone and back of the house phone. It's my understanding that what was described here was a back of the house phone with the LED display.
The purpose of those back-of-the-house phones is what?
Well, again, it gives us the ability to see who's calling so we can answer with their name, if possible, and in cases of emergency, so we know precisely where the call is coming from.
And why would that be needed in the hotel?
Well, Marriott has pretty strict standards on the customer care, and so it's constantly using the guest name as one reason, and the management company here, Windsor, was trying to live up to those standards as we discussed. But again, on the emergency side, sometimes a child may pick up the phone and dial out, or maybe somebody is having a panic attack or an emergency and they just don't remember the room number that they're in. And so that gives us the ability to know precisely where that call is coming from, so we can get to them quickly, dial 911 and make sure that the emergency responders can get to the room quickly without having to, if you got 300 rooms, you want to know where people are.
With respect to, obviously you're aware of what happened in this case.
Yes.
with Ms. Andrews. You had mentioned very early in your testimony that you had done a literature review.
Yes.
Why did you do that?
When you think about foreseeability, you want to look and see what, who or if anybody was talking about this, or if there had been any previous incidents similar to it. And so that's what we were looking for when we did the literature review.
In 2008, September of 2008, did you hear about this? When it happened?
I did not hear.
I'm sorry, in 2009 when it became public.
I did not hear about this until it became public.
And when did you hear about it?
Objection, Your Honor. 2009 is after the event. What hearsay? What did you hear?
When you heard about this incident, when was it? I'd like to clarify that for the record. I garbled it. I apologize. When did you hear about this incident?
It would probably have been, I honestly don't know the exact date, but once this became public, of course, lots of people in the industry began speaking about it. And certainly my interaction of the people I interact with, Security Council of the American Hotel Lodging Association, with all the security directors of all the hotel brands. That's when it came to their attention. That's when you started seeing people write about it, and so that's when I became aware of it pretty quickly.
After it happened, how soon did you hear? I'm sorry, but after it became public, how long was it before you think you heard?
I'm sorry, it's difficult to pinpoint, but it probably would have been I'd say a couple of weeks or a month. Yeah. Could have happened the day that the media picked it up, but sorry, I don't recall exactly.
Fair enough. When you did your literature review, well, hey, let me ask you this question first. When you heard about this, had you ever heard of something like this happening before?
No.
In your literature review, what did you find relative to that specific question?
Objection, it's the motion in limine, using it as an offensive literature. I don't know what he's going to say. He's going to quote literature, which is not right.
Objection.
What, if any, knowledge... Your Honor, may we approach? I don't think that's correct. Now, Mr. Delmarva had given an opinion on awareness of an incident such as this in his testimony to this court. Did you read that?
I did.
Do you agree or disagree with his opinion with respect to knowledge of something such as this before it became public and contested?
If I remember correctly, I don't believe Mr. Delmarva remembered something specific like this. I think his thoughts when he had heard of tampering with a peephole previously. But he may very well have heard of something like that. But I did not know anyone in my realm of security experts, corporate counsel for hotels, anybody that had ever heard of something like the extent that went on with Miss Andrews. For that matter, haven't heard about it since. So
you have also said that you have opinions with respect to obligations the plaintiff and ESPN had relative to safety and security while traveling. What opinion, if any, do you have there?
Businesses have a responsibility to provide their employees with orientation, training, procedures to assist them in being safe and secure when they travel. And certainly in 2008 that was the case, and certainly for companies the size of ESPN. So one would have thought that if...
Excuse me, Your Honor, I object to what... This man is not an expert on ESPN sports TV shows.
Was his mission in his Route 26?
Yes, sir.
Yes, Ben.
Yes, sir, I've got it right here.
Is it true?
I can hand it to you.
I need to keep writing testimony.
Can we approach right quick? I'll have a quick question.